Good evening, ladies and gentlemen. Welcome to Government that act as advisors to this board. To my left is Valerie Manzo, counsel to the board. To her left is Allison Murray, a planner in the planning department. To her left is John Bongino, town building director. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve so that those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approvals, site plan approvals, etc. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of applications before the board are area variances. Area variances deal with dimensions such as lot area, frontage, height, setbacks, and parking spaces. New York State statute mandates that the board must consider the following 5 criteria in area variances. When you come to the podium to present your application, you need to address these 5 areas. They are posted here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interest of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variance shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception variances are different than area variances. When we have a special exception application before us, I will explain the different criteria. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Mrs. Murray, and then you will be sworn in at the podium. And then you'll be given the opportunity to explain to this board why you need the variance. If the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity. So please, organize your thoughts, keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will close the cases and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. Number 1, you can wait until after the public hearing, but there's no guarantee that the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. And number 3, applicants can wait and be notified by mail. Okay. First case tonight is case 16472, 375 Rob Roy Drive, LLC, 375 Rob Rowe Drive, Hauppauge. Location, north side of Rob Rowe Drive, east of Old Willits Path, Hauppauge. Property zone LI. Request variance to reduce landscape area in front yard from 80% to 66%. Reduce the minimum parking setback east property line from 6 feet to 0. Reduce the required parking spaces from 30 to 26. Are you ready?
Yes.
May I have your name, please?
My name is Stephen Jaycox,
And your address, Stephen?
375 Rab Road Drive, Hop Hog, New York.
Okay. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do.
Are you an officer in in the corporation?
Yes, managing partner.
Managing partner?
Managing partner.
Okay. All right. You want to tell us why you're here, please? Spelling of your last name.
Jaycox. As already mentioned, I am requesting a variance to reduce the landscape area from 80 to 66%, to reduce the minimal setback from 6 feet to 0, and reduce the parking spaces from 30 to 26. The original, the condition, to answer number one, is not an undesirable change because it already exists. I'm just trying to beautify the property better and to allow the property to come into variance. The building was originally designed for 12 parking spaces when it was first CO'd, and it has not gone under review since that time. Obviously, the department has changed the number of spaces required for the building. The prior owner of the building had expanded the parking lot but did not get a variance from the department. So I'm looking to clean up that omission by the prior owner and bring it into compliance. So to answer question number one, it's not an undesirable change. The benefit sought by the applicant is feasible. It's not substantial. Other buildings in the surrounding area, within 200 feet of my own building, already have existing conditions, which I'm looking to achieve for this property. And it was not self-created.
Planning?
No comments.
Gentlemen?
No, ma'am.
Okay. Okay. Thank you so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Ready, move in second. All in favor?
Aye.
Motion carried. Next case is case 16473, Elizabeth and Jerry Paolillo, 801 Meadow Road, Smithtown, location north side of Meadow Road, west of Route 25, Smithtown property zone R21. Request variance to reduce minimum side yard from 16 feet to 13 for an existing pool. Reduce the minimum side yard from 16 feet to 10 feet for an existing 196 square foot cabana. Reduce the side yard from 16 feet to 2 for an existing 125 square foot shed. Reduce the total side yard from 34 feet to 12. Increase the paving in the side yard from 25% to 45%.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. My office is at 1038 West Jericho Turnpike, Smithtown, New York. I know some of the members visited my client's property, so I don't have to tell you how well maintained that property is. One of the situations with this property is that it's very long and it's only 100 feet wide. So, and the other issue becomes with respect to that more than 25% paving, the way the town measures the area called a side yard is they measure the front yard setback, which on the survey, I believe you have it, is 50 feet. The rear yard setback is 75 feet. So that's 125 feet. The rest, let's see, 278, about 250 is calculated as a side yard. So that long driveway going back, that asphalt, is considered all side yard, and if you do the math, yes, it does. It is more than the 25% that's permissible. The swimming pool does encroach on the side yard. It's really a minor encroachment. There's the cabana that encroaches a little bit more, but again, we're talking about a very long piece of property. The neighbors to either side are not affected, and the interesting part about this is Mrs. Paolillo indicates to me that years ago they did apply for a permit for the swimming pool, and they also went to the DEC, and for some reason or other, they thought that they had the permits. The permits obviously expired. Permits were never issued. And then I believe the building department discovered this file, and then, of course, approached Mr. and Mrs. Paolillo and said, hey, you better get permits for this stuff. And that's what happened. We don't feel that it will have an adverse effect on the character of the area. These are all long, narrow lots. They end up and terminate at the Long Island Railroad right away. This is on Meadow Road. It's a very busy street, as you all know. Whether the benefit sought by the applicant could be achieved by some other method, it's very difficult with such a narrow piece of property to squeeze everything in. I guess it could have been done, but it wouldn't have been as nice as the way they set it up, so that everything is kind of spread out a little bit. Yes, there is a little bit of an encroachment, but it's not substantial, which brings me to number 3, whether the requested variance is substantial. We think not. It's an acre of property, backs up to the railroad, and either neighbor on either side have, from what I understand, no objections to the application. Will it have any impact on the environment? Absolutely not. Standard kind of a thing, a swimming pool and a cabana and a small storage shed in the rear. Whether the alleged difficulty was self-created, in some senses it was. They did have the knowledge, and they did apply for the building permit some years ago, I think about 12 years ago. And then it was discovered that expired, as I explained before. So maybe it's partially self-created, but given the facts of the case, and I know the board saw the property, I think it's a good application. So we ask the board for its favorable consideration.
Mr. Tramarko, do you know we do visit, as you said, and we were there on Monday. When we looked at the side yard, there was playground equipment and a trampoline.
I'm sorry?
Playground equipment and a trampoline on the side yard. I believe that the building department considers them structures. Now,
I don't know that they do, because they don't require building permits, as far as I know.
They don't require, you are right, they don't require a building permit, but they do need to meet zoning. All structures need to meet zoning. There could be a second criteria that the structure could require a permit. Those structures would just need to meet zoning.
so, you
May I
know,
just say something?
just 1 minute.
Oh, I'm
all
sorry.
right? Yes. So the applicant can comply and move them, or she can come in and ask for variances for them, whatever she'd like to do.
We're going to be taking them down, because the
I got to
kids-
swear you in before
Oh,
you
I'm
speak.
sorry. I'm so
Let
sorry.
me have your name, please.
Elizabeth Paolillo. at
And your address, please.
801 Meadow Road, Smithtown, New York, 11787.
All right, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do. We're going to be taking those down because my children now are older and like they just sit there and we just haven't gotten to that part yet.
Okay.
But I will take those down so we don't have to worry about them.
Okay, perfect. Thank you
Okay.
so much.
Thank you.
Obviously, the board can make that a condition of approval of the variance. Thank you.
Thank you. Planning? Gentlemen?
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second?
Regularly moved in second. All in favor?
Aye.
Aye, motion carried. Next case is case 16474, John and Joanne Solicito, 43 Twix Hills Road, St. James locations, outside of Twix Hill Road, east of Twin Court, St. James, property zone R43CL. Request variance to permit environmentally sensitive land to be altered, slopes in excess of 15% for regrading.
Madam Chair,
Yes.
the affidavit of posting was notarized yesterday rather than today. Do you want to see if there's a notary here?
Did Mr. Tramarko leave?
Oh, Jan's here.
He's in the hall.
Jan's here.
Okay.
There's
Oh,
a notary here.
all right, there's a notary here, so right after we hear your application, we'll ask you to notarize it.
Thank you.
You'd be able to find someone here. Okay. May I have your name, please?
Sure, John Solicito,
And your address?
43 Twixt Hills Road, St. James, New York.
All right. Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
Yes.
Okay. You want to tell us why you're here? And use the mic, please, if you can.
Sure. When we purchased our home 2 years ago, there was existing structures in the backyard that were built by the previous owner without permits, so we were required to remove all structures, which we did. We have removal permits for those structures, as well as the removal of an in-ground pool. What we're here for today is to get a variance to regrade the property in the backyard where all those existing structures were removed. Under number one, it's not an undesirable change. It's actually a very desirable change because the structures that previously existed were old and decrepit, and that's why they had to be removed. Can it be achieved by some other method? No. I mean, you know, the structures were removed. We have to grade the property around it, so there's really nothing else we can do. The variance is not substantial because, as you'll see, all we're doing is grading around where the structures existed. We're not increasing any of the grades. Rather, what we're doing is flattening it so that we could rebuild, hopefully next year, with the new pool, which we will obviously get the required permits. Is it an adverse effect or impact? No. Like I said, it already existed, and actually, it's no other encroachments on our neighbors. We're not pushing it out on any property line. It's a property line that already existed, so it doesn't affect any of those lines at all. And was it self-created? No, it wasn't self-created. As I said, the structures existed. We were required to remove, and we did. So now what we want to do is just finish the job with the regrading.
Okay, thank you.
You're welcome.
Planning?
Just a quick question. The survey shows that the rear, approximately 30 feet of the property, is wooded right now. Are you planning on clearing the property when the regrading is done, or keeping the trees?
No. No, all we're doing is regrading. There's no clearing of the property.
Thank you.
Yep.
Okay. Gentlemen, any questions?
No question.
Okay, thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second?
Readily moved in second. All in favor?
Aye.
Opposed? Motion carried. Janet Haberly right here will do it for you. Okay. Next case is case 16475, Kathleen and Scott Regan, 37 McKay Drive, Hauppauge. Location, northeast corner of McKay Drive and Salem Path, Hauppauge, property zone R10. Request variance, reduce the minimum front yard from 40 feet to 37 for an existing 32 square foot portico. Reduce the minimum front yard on Salem Path from 40 feet to 5 for an existing 6-foot fence. Remove the minimum side yard, reduce the minimum side yard, reduce the minimum side yard from 12 feet to 2 for an existing 100 square foot shed. Increase the maximum permitted paved surface in the rear yard from 25% to 53%. And your name, please.
Kathleen and Scott Regan, and we are at 37 McKay Drive, Hauppauge, 11788.
Okay. Both of you raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
We do.
Okay. You need to use the mic, and you can take it out if you need to.
Okay.
Okay?
Okay.
You want to tell us why you're here, please?
We are requesting several variances. The first of which listed was to reduce the minimum front yard from 40 feet to 37 feet for an existing portico. The portico was done with recent home renovations, and the addition of our second floor, we had the high ranch with the substantial overhang, and so we lost that around the entire house, but specifically over the front door space. So the portico was added to give some shelter just coming in and out of the house in the weather. The second request was to reduce the minimum front yard, specifically the Salem Path side of the yard, from 40 feet to 5 feet to allow for our existing 6-foot fence. This is a side street that is half Islip as well and half Smithtown. It has we're between the Northern State, the LIE, the courts, we're kind of in between all of that. And there is no lighting on this side street, no other homes no homes at all, including our own, face on this street. Individuals, private citizens, as well as companies, FedEx, the U.S. Postal Service, people stop there, eat their lunch. I take pictures. I've taken pictures for the benefit of tonight, just to show people come, they sit for 10 minutes, 20 minutes. In vehicles, we don't know them, obviously. Some days a half an hour while my children are playing in the yard. So our main concern there is the safety of our family. 4 children under the age of 8, and their safety is really the point of that request, keeping the 6-foot fence at that location, which had been there for all previous owners. That 6-foot fence stockade at that same location and height. Our third request was for reducing the minimum side yard from 12 feet to 2 feet to allow, again, for an existing shed that was created by previous owners on the property and is still obviously maintained by us, but has not been changed in any way. We're just utilizing the shed that had previously been there. And to increase the maximum permitted paved surface in our rear yard from 25% to 53%. The 25%, our understanding when we had moved into the house was we didn't understand that side, what we thought of as our backyard, was partially considered front yard space. So, we never took into account how much paving was there. None of the paving is actually anything that we've done. Again, it is all previous owners' paving that had been done prior to our ownership on the property.
We were at your property yesterday.
Yes.
You know that. We spoke with you.
Yes.
And Mr. Flynn, who is the assistant director, I think we looked at your paving, and it seems to be, and I'm not sure, we'll have to make a decision, but it was done before 1990. That's when the ordinance came in, as far as percentage.
Yes. Yes.
So, all right. As far as the shed, that should have come up when you went to closing, because it does
Okay.
have, it's in violation.
Okay. That
All
was
right.
that was never at that time anything
Yeah,
that was
that-
mentioned to us.
That was 2 owners ago
Yeah.
also. so,
Yes.
but-
Okay. Planning?
May I also share one last thing?
Sure.
I know that the height of the fence being the concern there on that side road, I did take pictures from actually my driver's seat as I was pulling up that side of the road, so that there would be a visual to see how that intersection is seen from a driver, just so that if that needed to be seen, I could give that to you.
Okay, are they labeled, those pictures?
Yes.
Okay, you can hand them in to me. Okay. Planning? Gentlemen, any questions?
No, thanks.
Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Readily moved and second. All in favor?
Aye.
Aye. Motion carried. Okay. I can't hear you. Next case is case 16476, Pit Stop, 231 West Main Street, Smithtown location, northwest corner of Route 25A and Edgewood Avenue, Smithtown, property zone NB. Request variance to reduce minimum ground sign setbacks from 5 feet to 0, 2 existing signs. Increase the maximum number of ground signs from 1 to 2 existing. May I have your name, please?
My name is Mehmet Bulat,
And your address, please?
231 West Main Street, Smithtown.
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
I do.
Now, are you an officer, or are you an owner?
I am owner.
You're the owner, okay. All right, you want to tell us why you're here, please? Wait a
I
minute.
am here.
It's right on the application. You want me to have it spelled? No, thanks, I didn't see it. Okay. Go ahead.
I have two price sign, and one on the Edgewood side, another one on the Main Street side. And one price sign were to close my pump. When people coming in and going, they were hit to pole. Then I moved this sign pole to west side, 30 feet, 40 feet, to Edgewood, Dunkin' Donut and my place border. I am here for this sign.
Okay. Okay. Does he know what an LWRP is, I guess? Do they understand? Can you use a microphone?
I believe that our office contacted you earlier this week or last week to let you know the board cannot act on this application tonight because they need the determination from the town board for something called a coastal consistency determination. If you'd like, after the meeting, I can go over it with you.
No, I stopped by today, but nobody say anything.
Okay, so I'll talk to you about it
Okay.
after this meeting. Thank you.
Okay, thanks. Yeah. Okay. Gentlemen?
No questions.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain the votes.
So moved.
Do I have a
Second.
second? All in favor?
Aye.
Aye. Motion carried. Next case is case 16477, Catherine and Paul Farrell, 60 Walter Court, Comac, location south side of Walter Court, east of Fern Drive, Comac, property zone R10. Request variance, reduce the minimum front yard from 40 feet to 33 for an existing portico. You know what? You okay there? No. I was going to say, why, you can take that mic right off there. All right?
Okay.
That's good. Thank
Thanks.
you. May I have your name, please?
Paul Farrell,
And your address, Paul?
60 Walter Court, Comac, New York.
Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. You want to tell us why you're here, please?
Yes, we'd like to get a variance for an existing portico over the front stoop of our house. Obviously, I'm in a wheelchair. I've been in a wheelchair for about 10 years. It is a permanent condition. Our house faces north, and in the winter, we get absolutely no sun on the front of the house. Snow, rain, any precipitation more or less immediately turns to ice. This previous winter with the big snowstorms we had, and even after the snowstorm, once things begin to melt, the entire front walkway, including the stoop, turns to a sheet of ice. I need a way to get out of my house. Even to go out the back, the back door to come around the front is a problem because I have to go down that walkway, which is adjacent to the stoop. We put the portico over the stoop in an effort to protect the stoop and prevent the icing of the front of the house. According to your chart, it's not an undesirable condition. It actually improves the aesthetics of the house. It's definitely not a detriment. It actually is prevalent in our neighborhood. There's many houses that have that look. It's obviously necessary for me to get in and out of my house and to get to my driveway, to get to my car. The variance is definitely not substantial. It has no adverse effect or impact on the neighborhood, and it's definitely not a self-created situation.
Okay. Gentlemen?
No questions.
No thanks.
Okay, thank you.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
All in favor?
Aye.
Aye. Motion carried. Next case is case 16478, Robert and Janine Sassis, 74 Tulip Wood Drive, Comac. Location, north side of Tulip Wood Drive and east of Shinbone Lane, Comac. Property zone R10. Variance to reduce the minimum rear yard from 50 feet to 40 for a proposed 400 square foot porch. Increase the maximum permitted paved surface in front yard from 25% to 50%. Increase the maximum permitted paved surface in the rear yard from 25% to 40%. Increase the maximum permitted paved surface in the east side yard from 25% to 90%. Increase the maximum permitted paved surface in the west side yard from 25% to 65%. Ready? May I have your name, please?
Robert Cecere, 74 Tulip Wood Drive, Comac, New York, 11725.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Would you like this lady to speak for you?
I would, thank you.
Thank you.
Good evening, members of the board. Janet Haberly here on behalf of Mr. and Mrs. Cecere.
Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Certainly. Okay, we're here this evening for two variance requests, one for proposed roof over porch in the rear yard, and the second for increases in permitted paving percentages where all the paving is already existing. To address the proposed work first, we are in an R10 zone where 50 foot is required for a rear yard. The house currently has 60-foot rear yard, and the porch would go out 20 feet, leaving a rear yard of a little over 40. This would not be enclosed. This is simply going to be a little roof-over patio. The second variance request is for excess paving in the front yard from 25% to 50, rear yard from 25 to 40, the east side yard from 25 to 90, and the west side yard from 25 to 65. All of this paving goes back to at least 1998, according to the aerial maps that were reviewed at the Planning Department. I reviewed them with Allison. The paving regulation limiting the amount of paving to 25% for each yard went into effect on February 13th, 1990. A copy of those regs have been given to the chair lady. I'd like to give the board some history on this site as far as the paving is concerned. The house was purchased in 1997 by Giovanni Battaglia, who was a stonemason. He is the person who did all of the paving. He then sold the house to Castelli in 2008. Mr. and Mrs. Cecere just purchased the house last December. They haven't been there very long at all. They have 4 children, they needed bigger space, and they've been living in Comac since 1995. When Castelli purchased in 2008 from Mr. Battaglia, he had added an attached 2-car garage for which he obviously needed a permit. He obtained a permit, and the building department made all of their required inspections. Everything passed, and the CO for that garage was issued. This was in 2008, which is 18 years after the paving regulation went into effect. No mention was made to the homeowner about anything needing to be filed for the paving from the building department at that time. When Mr. and Mrs. Cecere decided to buy the house, Mr. Cecere did his due diligence. He went down to the building department, reviewed the property card to make sure that all of the COs that needed to be addressed were there and existing already. Finding everything in order, they purchased the home. In all honesty, I don't know how anyone, truthfully, would know you needed a permit for paving. I've been to many houses in Comac, and a lot of them have excess paving. Certainly, the average homeowner wouldn't know, and surely the paving companies don't bother to tell you. They're just like the pool companies. Just seems a little unjust to inherit such a problem. Let us address each of the 4 issues. The front yard. The driveway is a semicircle. The house is right at the bend of a curve, as you can see from all the photos that I've submitted. So this shaped driveway is both safe and allows the household traffic to access the road more easily. On top of that, there is a large planting area in front of the house, which conceals the part of the paving that is behind that landscaping to the front stoop. The house is also on a little bit of a hill. It's a little elevated. And the neighbor that is directly across the street, Mrs. Marchese, has signed an affidavit, which I've given to the board. In support of this application, she has no problems with that front yard paving. The rear yard. A good portion of that paving was installed with the in-ground swimming pool in 1970. Mr. Battaglia added some more patio pavers just to make a larger size patio by the pool. The east side yard. This involves the largest request for relief. However, there are strong mitigating factors here. The Cesare's property abuts vacant land. Their home ends the R10 zone on that section of the street, and adjacent to them is vacant land zoned L1. And that portion that you can see from the photos that I've submitted of that vacant land, that is part of the buffer that is required between the residential area and the industrial area. That property cannot be developed, and so there is no neighbor on that east side that would be affected by the amount of paving that exists there currently. I've also submitted copies of the tax maps showing exactly where all of these properties are located, and to emphasize the curve in the road there at that intersection by the vacant property. The west side yard. This side yard is paved with larger block than some of the other areas, which are more elaborate. Additionally, the neighbor to that side, Mrs. Mulvey, has also signed an affidavit in support of the application. You can't really even see that paving from her side of the property because it's so well shielded by the fence that's there. I submitted the 2 affidavits, copies of all the documents I've mentioned, along with 14 photos. And the stack of photos are photos of number 71, 72, and 90 Tulip Wood, all with excess paving and number 110 Florida Avenue, which is the property that abuts the Cecere property to the rear. I did check all the property cards. None of those four addresses have COs for the paving, and I admit that, I offer that information just to show some conformity with the area, but I know the board's concerned about that. To address the 5 proofs regarding any negative impact, well, the neighbors to the west and across the street have no problem with the request. Obviously, they wouldn't have signed the affidavits in support. The neighbor to the rear can't even see any of it due to the tall trees, and the neighbor to the east is that vacant industrial property. The request for the roof over is only 10 feet short of the rear yard requirement. It's not going to be enclosed, so that we do not consider that a substantial request at all. The paving requests appear substantial, obviously, but we do believe that the mitigating factors lessen them. There are no environmentally sensitive lands involved in this application. As far as alternatives, well, the paving is obviously all there and has been for many years. And the roof over is situated so that it will come off the den, and there's a little bump out to the left of the rear, so it really has no other place where it could be put, especially with the pool there as well. As far as being self-created, well, obviously the roof over isn't because nothing's been constructed as yet. And the paving was self-created, but certainly not by my client. So we thank the board for its consideration.
Okay, thank you. Planning? You got to use a mic.
Sorry, just one question. You said that the in-ground pool was put in around the 1970s. Is that right? Was the stone patio around the pool put in around the same time? Do you have any idea about that?
A little later when Mr. Battaglia went in there.
Okay,
Yeah.
thank you.
You're welcome.
Okay. Planning, do you have, gentlemen?
No.
Okay, thank you.
Thank you very much.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's readily moved and second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16479, Vincent and Lorraine Privado, 17 Locust Drive, Kings Park location, east side of Locust Drive, north of Maple Drive, Kings Park, property zone R10. Request variance, reduce the front yard from 25 feet to 0 for an existing pool, 100 square foot deck and a 6-foot fence. Did you do that on purpose?
Good evening.
May I have your name, please?
Yes, my name is Lorraine Privado,
Vincent Privado.
Okay. And your address, please?
17 Locust Drive, Kings Park, New York.
Both of you raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, we do.
We do.
Okay. You guys speak nice and loud, please, all right? And
Yes. As you just said, this is a request for variance to reduce front yard from 25 feet to 0 feet for existing above-ground pool, small deck, and fence. And the reasoning for this is my family owned this property and the one next door at 948 St. John Land Road since the 1930s, and it was once one large property. It included most of the block, and there was a pool in this location for most of my childhood memory. It was from when I was like 3 or 4 years old on. There was a pool here, and the reason I remember my relative saying it was in that spot was it was the only place that there was sunshine because the rest of the area was wooded or had many trees, and this was the only area with sun. San Remo was not developed at that time. The particular pool was here before we moved, my husband and I moved back into the family home in 2000. It has not impacted the neighborhood. In fact, across the street is almost the exact same situation, and the nearest north neighbor is over 200 feet away. No one has ever complained, There is a 6-foot fence that surrounds it and is locked when it is not in use. I have a form of rheumatoid arthritis called ankylosing spondylitis, where my spine is telescoping, and really the only place that I can get relief from pain and to get any exercise in is in this pool. It would be a great hardship for me to be without it. I am in it every day, often more than once. We wish to use the area for this above-the-ground pool temporarily. This pool is old and it won't really last all that much longer. When it is ready to come down, it will be removed and sprinkled with grass seed, and the grass will come back as if it never existed. Or if you have the letter from Mr. Jorgensen, if the town should need it before that time, of course, we would take it away immediately. That we agreed upon, of course. We also have a letter from the environmental gentleman, and I did submit that, and they say it does not have any impact in the area at all. It has been here for many years. It does not deteriorate the neighborhood in any way. As I said, across the street is a very similar situation. When it rusts, it will be completely removed. It is temporary. It will not be replaced in this location, if ever, if we ever even got one. If we decide to move, it will come down before we move. It is necessary for my health and pain management right now. I do have medical documentation. If the board should require that, I can easily supply that. It would be difficult to have an alternative because the cost is prohibitive. It is old and would not survive being moved if we were to try to move it to another location. It is an above-the-ground pool. It does not harm anything. As I said, grass would return if it were taken away. It's an inherited family property, and unfortunately, when San Remo was not developed, my family did not realize, I suppose, that it would be an issue and put it in this area without really checking to see if it was the best, for, in years to come to have it here. It's very unusual that town property in San Remo would go back 16 feet. We drove around San Remo, and in many places, the front door is closer than 16 feet from the curb. So it just was something that surprised us when we learned that it was, that town property extended so far back. I just wanted to say, I guess that's about all I need to say right now. I think I handed in all the paperwork, but if there's anything else, we'd be happy to take care of that.
Okay, thank you. Planning?
No comments.
Gentlemen?
Okay. Your side fence, does that extend on your neighbor's property?
No? No, it's ours.
That's their property also?
Are you on the property on both sides?
I'm sorry?
You own the property on both sides?
Yes.
Oh, okay, I'm sorry.
Oh, okay. Yes, we do, right. Okay, I'm trying to picture where you meant, yes.
Right, thank you.
Okay, thank you.
Okay, thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's been regularly moved and second. All in favor? Aye. Motion carried. Next case is case 16480, Troy and Gina Pieneman, 3 Dilmont Drive, Smithtown. Location, east side of Dilmont Drive, north of Meadow Road, Smithtown, property zone R21. Request variance to increase the maximum floor area ratio of a lot from 25% to 30. Reduce the front yard from 50 feet to 20 for the proposed 151 square foot porch, an existing 72 square foot first floor addition, 273 square foot existing attached garage, and a proposed 885 square foot second floor addition. Reduce the rear yard from 75 feet to 14 for an existing 72 square foot first floor addition and a proposed 885 square foot second floor addition. And your name, please.
My name is Troy Peterman. I reside at 3 Dilmont Drive, Smithtown, New York.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, ma'am.
Okay. Is this gentleman going to speak for you?
This is my architect, yes.
Okay, thank you.
My name is Michael Dunn, D-U-N-N. I'm the architect.
Why don't you people sit down? It's easier for you. Oh, okay.
My address is 1981 Union Boulevard in Bayshore, New York, 11706.
Okay, raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
Yes. We are here tonight seeking several variances to do a second-story addition on an existing house. The original house was built back in 1952. The lot is very undersized lot for the zone of R21. It's only 95 by 80. That's important with this whole case. There was a one-story addition which was added back in 1978. That addition had a 14-foot rear yard setback, and we'll get to that with our new rear yard setback. So we're proposing a second-story addition to move the bedrooms upstairs, to open the floor plan downstairs for easier access and for a growing family. The second-story addition will only be 885 square feet. So we are seeking a variance for FAR. The maximum allowable is 25%, and we are seeking 30.9% FAR. The breakdown that I have is the existing house is 17.2%, and the new second story will be 11.6%. And we are adding a front porch because now it's a two-story house. We wanted to give it some aesthetics from the front, so we added a 6-foot front porch, and that was 2.1%, so that got us to the 30.9. The minimum front yard setback in the R21 zone is 50 feet. The original house was built with a 26.1-foot setback, and now we are proposing this 6-foot porch, so we are asking for 20.1 feet. The minimum rear yard setback in the R21 is 75 feet, and this setback, we are planning on building the second-story addition right above the existing first story. So we are maintaining that rear yard setback of 14.6. To me, the house, if built, would not be out of scale with the local houses. It would be in keeping with the style and the character of other homes in the area. It would not produce an impact on the adjacent properties. It's mainly a second-story addition. It's not substantial. I think the square footage is normal for that area. Because of the size of the lot, I don't think it can be achieved any other way, and it will not have any adverse effects on the local environment.
Do you want to say anything on health issues? We were asking for these variances for the dwelling for our home, for not only for a growing family, but also for medical reasons. I'm a police officer for the state of New York. I got hit by a drunk driver several years ago who broke my back. I've undergone several surgeries, and I've gotten some bad news from my doctors. On the first floor, the way the house is now, if I might be in a wheelchair, I won't be able to access my home. The house is it looks small from the outside, but it's actually smaller on the inside. It's a lot of little rooms, a lot of walls, so we're trying to open up a floor plan so I can still access my home. I would like the board consider that as well as for a growing family. Thank you.
I know this is a very small lot, and John, that 151 square foot covered porch, is that included in the FAR?
That was included.
Should it be?
The architect came up with a percentage of 30.9%.
Yeah. But I think that 2%.
I recalculated the floor area ratio, taking out the covered porch.
Okay.
It comes out to 29%.
Okay. Perfect. Okay. Thank you. Gentlemen? Okay. Thank you so much.
Thank you.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Readily moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16481, Frank DeMarco, 205 O'Willets Path, Smithtown location, east side of O'Willets Path and North Creek Road, Smithtown property zone R43. Request variance, reduce the minimum side yard from 24 feet to 9, 16 existing, and total side yards from 60 feet to 35 feet, 42 existing, for an existing 113 square foot shed. And your name, please.
I'm Frank DeMarco.
Use the mic, Frank. And
Frank DeMarco.
And?
Denise DeMarco.
Okay. Your address, please?
205 Old Willets Path, Smithtown, New York, 11787.
Okay. Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
I do.
I do.
Okay. You want to tell us why you're here? And who's ever going to speak, they need to speak into that mic.
We have a shed that was put up approximately, I guess, 30 years ago, 2 owners, I think, ago. It's on every survey that the town has going back to when they installed the pool and the garage, that, you know, the COs for all of that, and that shed was put there at that time. It is right next to our pool, so we use it for storage for everything for the pool. The way the property is fenced, if we moved it, it would be either outside the fence line of the pool or right in the middle of the small section of our property that's fenced in. Property is only 100 wide, very, very deep. It would not produce an undesirable effect. The north side, which is the property where it's closest to, there is about 30-foot Leland cypresses. Can't be seen by any of the neighbors. Let's see, is it substantial? No, it's been there for 30 years, and it would have no effect on the environment, because I said it's been there for 30 years. And this was not self-created. It was created about 30 years ago by the owners who put it in. So that's it.
Planning? Gentlemen?
No, thanks.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Really moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16482, Diane and Gerald Losito, 68 Joseph Place, Wisconsin location, west side of Joseph Place, north of Town Line Road, Wisconsin, property zone R10. Request variance to reduce the minimum front yard on Treetop Path from 25 feet to 2 for an existing 96 square foot shed.
Hi, my name is Joe Losito. I live at 68 Joseph Place, Wisconsin.
All right, raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay. And talk into the mic as much as you
Okay,
can.
I'm sorry.
Thank you.
Yeah, I'd just like to say back when I bought the house in 1982, there was a shed in that location. 1989, I replaced the shed with the existing shed that's there now. As far as, you know, the backyard, you can't really see it from the street. There's a bunch of trees that cover it. It's a little larger than the original shed that was there. I have no basement and no garage for storage, so I made it a little bit larger, but it is in the exact same spot. That's about it.
Planning?
The survey shows that the shed is on the property line. Is that correct?
That's correct.
It seems that there should have been a variance request to reduce the distance
Right.
from a property line from 2 feet to 0, or sorry, from...
25 to 0? No, it can't be 25.
No, it's not 25 feet. It's in, what zoning district is this? R10, it would be from 6 feet to 0 feet. That's an error on the town's part for not having
Right.
picked that up.
All right.
Thank you very much.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Beverly moved in second. All in favor?
Aye.
Aye. Motion carried. Okay. We'll be going to the adjourned cases. Okay. Steve, okay, you got it? Is it in there? Okay, good. Next case is case 16441, AAA Properties, 797 Middle Country Road. Let me do it this way. Okay, location, north side of Middle Country Road, west of Astor Avenue, St. James, property zone WSI. Request special exception to permit parking in a residential district. Special exception to permit repair garage. Waive special exception standards that required lot area to be adequate. Waive special exception standards that requires adequate parking. Waive special exception standard that requires adequate buffer areas and screening. Waive special exception standards that require lot to be in existence prior to the adoption of the zoning line. Reduce the minimum landscaping area between parking and front property line from 8% to 3.7%, 4% existing. Reduce minimum parking from 90 to 54 spaces and reduce the minimum truck loading spaces from 1 to 0. Reduce the minimum parking setback from property line from 20 feet to 6 feet, 8 feet existing, and reduce the minimum parking setback from side property line from 6 feet to 0. Variance to reduce buffer to resident district from 10 feet to 0. Vary standard that requires floor area to be less than 25% of lot area, 31% requested. Vary standard that requires 50-foot buffer, 18-foot buffer in residential district requested. That's it. Okay.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. My office is at 1038 West Jericho Turnpike, Smithtown, New York. I've submitted the affidavit of posting to Allison. The board may recall we were here, I guess about a month ago, and we presented the case. And one of the problems, the only problem that came up was the planning advisory report was not available. It has since become available. I hope that everybody on the board has a copy of it. It was sent to me a little bit after, probably July 8th. It's dated July 7th, and it goes through all of the requirements and ultimately comes up with a recommendation to the board, which basically recommends approval with certain conditions. One of the things that I just want to bring up is the original application was 90 parking spaces required to 54. It's really 63 to 54. At the time, there was a karate school still active, and now the karate school is out, so we're using the WSI warehouse requirement for that third unit. So therefore, the parking requirement is 9. The reduction is 9 spaces, not approximately 30-something spaces. As you can see from the report, Peter Hans from Planning wrote a very detailed report and made certain recommendations to the board. These recommendations have been reviewed by my client. They've also been reviewed by Carmine Grasso, our architect, and we find them acceptable, and we hope that the Board of Zoning Appeals will find them acceptable and grant this application. As you know, a similar application was granted. In a lot of respects, it was a similar application to my client's neighbor to the west, which is kind of a three-unit building built many years ago by the same builder. So we asked the board for its favorable consideration, and Carmine is here, and my clients are here if the board has any questions.
Planning, are there any questions? Gentlemen?
No, thank you.
Thank you.
Okay, thank you
Thank
so
you.
much. Mr. Tramarko? No action?
Tell me you don't have a secret.
I don't.
I think I'll write a letter to Mr. Barnett, see if we could help this along.
Okay. Do you know
Thank
what
you.
he's asking for? I guess, is he asking for all the minutes? Can I see?
What
Can I see that file again, please, Steve, if you don't mind?
What the DEW does is, as this board knows, waits for everybody, including myself, to present the case. Obviously, they don't come to the meetings like planning does. So, yeah, I guess they want to look at the minutes. Mr. Riccobono has to do the minutes, and I know he does them very quickly. So it's still going to take probably a month before, we get an answer.
That's exactly what he's looking for. He's looking for all the minutes.
Right.
Okay. Thank you.
You're welcome.
Is there anyone here that would like anything, gentlemen? No?
No question.
Okay. I'll entertain a motion to close the hearing.
So moved. Second.
Israeli moved in second. All in favor?
Aye.
Aye. Motion carried. I think I got it. Next case is case 16451, Sharon Gonzalez, Guzzi, 59 Croft Lane, Smithtown, location east side of Croft Lane, Easter Creek Road, Smithtown, property zone R43. Request minimum front yard from 60 feet to 5 for an existing 6-foot gate. Reduce the side yard from 24 feet to 0 and total side yards from 60 feet to 5 for several existing structures, including a front porch with a 12-foot setback, rear porch with a 23-foot setback, pool with a 14-foot setback, pool shed with a 10-foot setback, detached garage with a 13-foot setback, barn with a 13-foot setback, stable with a 1-foot setback, shed with a 0-foot setback, corral structure with a 5-foot setback, reduce the required distance from any lot line for an existing corral from 6 feet to 5, reduce the distance of the storage of manure from 50 feet to 40 from any side lot line, reduce the distance from front lot line from 3 feet to 0 for an existing retaining wall.
Good evening, Madam Chairman, members of the board. My name is Vincent Tramarko.
everything,
I represent the applicant. We've submitted the affidavits of posting and mailing along with the certified receipts. to Allison. You have before you a survey that's been marked up and color-coded so that you could better understand, and I could better understand, what's going on with this property. A couple of the things that are, let me have the property card. A couple of the things that are going on here is, for example, the pool was CO'd, I guess, well, I can tell you when, on 3/20/74. There was a dormer and a barn that was CO'd. There was a permit to erect a corral-type fence, all to code. If you look at this, I know it looks very busy. There's a lot of things going on this property. However, if you visited the property, and I know you did, you'll notice that everything is very well kept, and it's a very long, narrow piece of property. It is long and narrow, therefore, certain items are kind of crunched together, but everything is done in a, I would say, meticulous fashion. The request for the garage variance to 13.8. There's one stable in the rear that's 1.9 feet to the line, and you say, well, boy, that's close, but the neighbors on either side have no objection. I believe my son submitted letters from those neighbors, and they have no objection. One of the reasons is they're also people that have horses and maintain horses on the property. Another thing that you'll notice is that this property backs up to Suffolk County Parkland. I believe it's Blydenburg Park. So when my clients want to ride their horses, they don't have to go out in the street and across any roads. They merely go out the back corral gate. You can see it noted over there, and go into Blydenburg Park. So it really doesn't have any effect on any neighbors. However, what's the effect on neighbors that all own horses? There are horses on either side. There are horses probably in this area, more than 60, 70, maybe even 80% of the people that live here are horse people. And they're horse people because they're close to the location. They're horse people because it's close to Blydenburg Park, which they can ride their horses in relative safety. Blydenburg has, I guess, a bridle path. I know it has a bridle path that my clients and other people in the area use to exercise and ride their horses. This is one of the few areas where the access to Blydenburg Park is, well, in my case, in my client's case, it's just adjacent right to it. So you just, like I said, you open the gate and you ride the horse through it and you're in the park. But the other horse owners that are not as fortunate as my client who live on the east side of Willetts Path, excuse me, they don't have to go out or cross Willetts Path. They're all on side streets, Croft, Loft, and the like. And the reason why I say all of this is because this is one of the true areas where you can have horses, not disturb anybody, and enjoy the sport of horseback riding, and be in a position where you're not a nuisance to any of your neighbors. One of the things that happened many, many years ago, I can remember probably 20, 25 years ago. And we had the first situation with the manure bin. And the town board passed a law that said you have to be at least 50 feet from either side of the storage bin or manure bin. Now, one of the funny things was there are many, many, many properties that are 100 foot wide. And for some reason, they didn't take that into consideration. So I'm sure this board probably has, you know, in this board's tenure, probably 100 applications because of the manure bin situation. So of necessity, we have to ask for a variance that permits the storage of manure within that 50-foot requirement. There's a porch, roof over porch, which extends past the house, and it's about 12 feet. It's 12 feet from the property line, and we're asking a variance for that. Then we come to the famous retaining wall situation, which I've had a few of them since they changed the law. And obviously, before you could have, not obviously, I guess most of you do know that you could build a retaining wall right on the line. You can't do that anymore. You got to be, I think it's, John, I think it's at least 3 feet back. And for every foot the retaining wall is high, you have to go back. And I guess it was a safety reason. I guess the boards, the town board thought it was a good idea. The problem is there's so many existing retaining walls that I'm sure this board has seen literally hundreds of them come in since the ordinance was changed. Now, the other issue is the gate. Now, and I know you were there again, so this is a gate that opens and closes mechanically. It's an electrified gate, meaning it has a motor that opens and closes it, and really it's only the stanchions that are higher than the 4-foot requirement. And part of the fence, because it's kind of a dipping type fence, the rest of the fence meets the requirement, and it's only 4 feet, the front of the house. It's obviously something that my clients were not aware of. We've had a few of these come before the board. It's set back, so it's not right on the road. It's set back at least 22 feet or so, so it's not, you know, encroaching right on the road. And it's for two reasons. One, so the car visiting the property can be off the road, put the card in to open the gate, or call on the intercom and the occupants of the house open the gate. And I guess what I'm trying to say is it's not right on the road. It's not something that's an encroachment or a sight distance situation. It's back that many feet, like I said, at least about 22 feet. So it really isn't something that affects any other house in the area, and it doesn't affect sight distance or any cars driving along the road. So do we think this is whether this is an undesirable change in the character of the area? The whole place is horse properties. That's what it is. That's what it always will be. And that's why it's not changing the character of the area. This is the character of the area. Whether the relief sought by the applicant, could there be some other method feasible? Well, I guess you could, you know, have moved some of these structures back into that corral or paddock area. I'm not sure what you call it. Essentially a corral fence, so I guess it's a corral. But that would, you know, take away from the use of the property so that the horses could exercise and go outside when they're not being ridden in Blydenburg. Whether the requested area variance is substantial. Not when you look at the whole property, the size of the property, the fact that it's a narrow piece of property. These maps, the map of Timbercroft came out in 1942. It was filed in 1942. And in 1942, to have a 100-foot wide property and go another almost 400 feet, that was a big piece of property. When mappers came in, they looked at things like what did Queens have? What did the New York City have? So they never thought about making it wider than 100 feet. So most of the map of Timbercroft is 100 feet wide. So anybody that has a horse should come in for a variance for the manure bin, or they should change the rule and make it 40 feet from either side. Well, no, they could make it 45, probably, yeah, 45 feet, and give you a little leeway to keep the manure bin. Will it have any effect on the environment, the physical or environmental conditions of the neighborhood? Again, these are all horse properties. So it's not like my client's keeping horses there and the guy next door doesn't have horses and wants to be free of all the issues with respect to horses. And we're not saying that there aren't issues, but those issues for horse people are things that they love. They love to clean out the barn, whatever they call it, swap the barn for the manure and get it out of there and all of that stuff. And I know you looked at my client's property again, and you know how clean and well kept it is. Whether the difficult self-created. Some of the stuff, yes, was built without the benefit of a permit. But again, the neighbors aren't complaining about the closeness of the closest shed, which is a little less than 2 feet to the line. There is one shed that the tip of it actually, well, it says 0.1 foot south, so I guess, I don't know, it's right on the line. That's not a major thing. You know, if it has to be moved, you know, we'll move it. So we asked the board for its favorable consideration. One of the questions may come up, well, supposing the guy that lives on the south side or the guy that lives on the north side moves and some other person comes in and doesn't like the stable or doesn't like the horse corral and so forth. I'm telling you from the experience that I have and from speaking to my client, the only people that are going to buy there are going to be horse people. If it was anybody else that wanted to buy there, they would probably need to go have their head examined, because if you don't like horses, why would you want to live next to someone that has horses? So given all of the factors, we think that this is a good application. It's a well-maintained property. So we ask the board for its favorable consideration. I have my client here if there's any questions.
Is there anything? Gentlemen.
No.
Okay.
Thank you.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Is there any moved in second? All in favor?
Aye.
Aye. Motion carried. I'll take them, thank you. Thank you, Keith. Good, thank you. Okay, gentlemen. There's plenty, we don't need any more. Yep, we're fine. You can pass them on too. Okay. Let me read the application, please. Okay. Okay. Do they want to change the tape? Keep going? Okay. Huh? I'm sorry. Yeah, could be. Okay. Okay. Next case is case 16470, Cosmetics of Smithtown, New York, LLC. Locations outside of Route 347, east of Terry Road, Smithtown, property zone WSI. Request special exception to establish a 7,165 square foot repair garage. Variance to waive special exception standard that requires sufficient plot area. Waive special exception standard that requires adequate parking. Waive special exception standard that requires adequate buffer yards. Variance of a special exception standard that requires FAR not to exceed 25%. 28% proposed. Variance of a special exception standard that requires a 50-foot buffer zone, 10 feet buffered. 10 foot is proposed. Reduce the landscape area between parking and street from 8% to 5% existing. Reduce the aisle width from 24 feet to 22 existing. Reduce the parking setback from street from 20 feet to 13 existing. Reduce the parking setback from side lot line from 6 feet to 0 existing. Reduce required parking from 34 to 25 stalls.
Good evening, Madam Chairman and members of the board. My name is Keith Archer of Harris, Bloom & Archer, 445 Broad Hollow Road, Belleville, New York, and we represent the applicant in connection with this request for a special exception and variances to modify the existing, as the chairwoman said, 7,165 square foot building, existing building situated at 737 Wisconsin Highway for the purpose of, and we're going to get some more details on this, for the purpose of establishing a cosmetics repair facility. Now, we all know that the property that's the subject of this application is situated on Route 347, south side of 347, between Terry Road and Southern Boulevard. This board is well aware of the commercial uses that exist along Route 347. We all are. We probably drive it all the time. And just to point certain things out, not too far, maybe 6 or 7 buildings to the east of the subject property, there is an existing auto body store. As a matter of fact, I think we're going to hear from Mr. Zolo tonight, perhaps, on behalf of Third Generation Auto Body. There is also a Monarchy muffler store, as well as I think a tire repair store, which is a little bit further to the west, closer to the subject property. And I believe there's also a power tool sales store situated, again, a little bit closer to the subject property. The only reason I'm mentioning this is because, just to kind of reacclimate everybody as to where we are on Route 347. Now, the site itself, we'll get down to details. The site itself is 26,409 square feet, or 0.61 of an acre. And as you mentioned, Madam Chairman, the property is owned WSI. Now, the existing building on the site was previously used, and it's probably been used for several uses, but if you look at the signs on the building that are still there, it was used as a swim center and for physical therapy. As indicated on the letter of denial and as indicated on the plans that were submitted, the building itself is non-conforming dimensionally in several respects. It was built at a time that the zoning requirements were different. So while we may be asking for variances, the variances are being requested principally, there's one or two exceptions, principally as a result of the existing location of the building. Now, one of the things that I just wanted to clarify for the benefit of the board is that the lot area of the site actually does comply with the special exception standard. Special exception standard, I believe, requires a lot area of 20,000 square feet. And that special exception standard is, of course, for a repair garage. The lot is actually 26,000 square feet. So it would, I think Allison would agree, that, that it would comply with that standard. And also, I just wanted to point out that the applicant, I don't believe, requires a waiver of the special exception standard for parking or for lot area. Because I think that was also mentioned in the letter of denial, and perhaps and I'll talk about that in a moment, in the planning department report to this board. Parking is not a special exception criteria. Again, you can correct me if I'm wrong, Allison. And neither is the lot area, but it complies with the 20,000 square foot lot area. Offering testimony, I realize that I'm the last application, and I'm going to try and keep it as brief as possible. But I think it'll be very instructive for all of us to hear from the principal of the applicant who actually operates these facilities, these cosmetics facilities, because they are very different from your typical auto body shop. The scope of the work that they perform is a scintilla of what's allowed to be done in a repair garage. So I think the best thing to do is to ask that the board allow Ron Duckstein to describe for the benefit of the board, and then I'll be back, the operation of a cosmetics repair facility, what it does, particularly what it doesn't do, and how it operates, in a very environmentally safe and clean way. But let's have Ron describe the operation, if that's okay with you.
That's fine.
Thank you.
Okay. First of all, Ron, I need to have you do your first and last name and spell your last name.
Ron Duckstein, D-U-C-K-S-T-E-I-N, 1134 Gambelli Drive, Yorktown, New York, 10598.
Okay, raise your right hand. You swear to tell the whole truth and nothing but the truth?
I do.
Okay, you need to use that mic and be as loud as you can.
How am I? Good?
Good.
All right. I want to talk a little bit about what Cosmetics is, the company, what our franchise is, a little bit about our concept, and about the facility a little bit. I know this is late, and I'll make it as brief as I can. We are out of, it's a Florida company. I'm not part of that Florida company, but I'm a franchisee of the Florida company. They've been around for 15 years. They do minor auto body repairs. They call it drivable auto body repairs. They have 15 locations down in Florida. My partner and I formed a company called Cosmetics Tri-State. We are the principals of this location, and we have the area, the tri-state area, to develop as many of these locations as we possibly can. Currently, we have one open in Greenbrook, New Jersey, and on Monday we open our second one in Union, New Jersey. My partner and I have been in business for over 20 years. I live up in Westchester, but I lived on Long Island for 25 years and have worked on Long Island my entire life. I opened up all the Outback Steakhouses on Long Island and owned them and sold out of them in 2005. And I was just with Outback till about a year ago. My partner was the COO of the entire company. That includes the Carrabba's across the street. And you know how we operated those businesses, and we think we'll operate these businesses in the same manner. The cosmetics concept itself, it is auto body. I'm not going to say it's not. It is auto body, but it's an auto body with a different twist. We repair only drivable cars. We only take drivable cars. The idea is to take these locations, place them in retail areas where it's very comfortable for customers, spouses, whoever, to just drop their cars off and pick their cars up at the end of the day or at latest the next day. Most of our repairs are a day, day and a half. The average cost of a repair at a cosmetics is only $600 per car, and I'm sure you guys have had some auto body work done. You don't get a whole lot of auto body work done for $600. These are dents, scratches, some fenders, some hoods. Most of our cars, again, are delivered in a day, day and a half. Our parking lots do not look like an auto body parking lot or even a car repair parking lot. It looks like any other retailer. They're gone in a day, day and a half. We don't have cars that sit there for 2, 3 days. The exception is 2 days. We do not keep cars outside. We do not do work on cars outside. We don't do any mechanical work on these cars. No oil changes. We don't do anything with even radiators. Whatever work that we can't handle, what we usually do is when we go into an area, we'll identify a local body shop that is highly regarded, does good work, and we refer that work to them. And to tell you the truth, now already those guys are sending some work back to us that they just can't get to, and they're not going to give us work. It's something that either they give it to us or the customer's going down the road because they want the car done in a day. And it's been working out pretty well so far. Our goal is to do 10 cars a day. That's a stretch. We're averaging in the company, and that's down in Florida, about 6, 7 cars a day. Right now, we're doing about 3, 4 cars a day. Our motto is fast, flawless for less. I'm not exactly going to say we're always going to be less. We're not the maker of the world. We do quality work. We use DuPont paint. We guarantee our work for as long as you own the car. We guarantee as close to 100% color match as you can get. I used to say 100%. After being in this business for a year, I know there is no 100%. And again, most cars are delivered and repaired the same day. Our facilities, as you can see, this is a prototype on the top. It's not going to look like this, but it'll look something like this. As you can see, it's a nice, clean, contemporary look. The interior that's down below on the folder, that quote area will look just like that, and the weight area will look exactly like that, both of them. What we do is we put these tables in the quote area. You sit down with the manager or the general manager. There's a computer there. He generates the quote right in front of you. It's not an estimate. It's a quote. We guarantee that quote. If we find that there's additional work, supplements, we eat it, and that's what we've been doing, and that's the concept of the company. Your quote, we guarantee. We find something, that's our problem. And the reason why we can do that, again, I'm sure these guys will say they're crazy, but we don't do that heavy work. So we don't take those big hits, so you can see exactly what that damage is. Once in a while, we make a mistake. A question might be, well, what happens if you pick up a car and you find out that you can't repair it? Well, we go to the customer and we say, you have your choice. We will get it to the guy down the road, or we'll put it back together for you for no charge, and you can take it back. It hasn't happened too often. That has never happened to us right now, but we've only been open for 3 months. Each facility will have a general manager and a manager. We put them in a uniform. I tend to look at it, the old commercial, the man with the star, a clean-cut individual who is going to address our customers, articulate exactly what the quote is going to be, and make sure they understand that we're trying to bring hospitality to this business. And the perception of the business is not great. And what I found out over the last year, there's a lot of good guys out there doing this work that do have that reputation of doing real good work and having integrity. Unfortunately, the select few that don't have really made it difficult for that auto body industry. Because that was my perception before I got to know a lot of people in the auto body industry and a lot of the auto body shops that surround us. In that weight area, someone comes in and gets the quote. We offer them beverages, coffee, sodas, always available. There'll be about 6 to 8 employees total, depending upon volume. Most likely with this one, we'll hire 2 managers and 3 guys in the shop. We have very limited on-hand inventory, and I didn't realize, but most body shops do. You only keep the paints that you absolutely need. Our standard of cleanliness is immaculate in the shop, And I know I'm driving my guys crazy right now because I just want a clean, clean shop, and I want that reception area to be absolutely immaculate. They keep on telling me, Ron, you're not in the restaurant business anymore, but I think that'll differentiate us from other people, making a real comfortable environment for our customers to come into. Of hours of operation, 7 a.m. to 7 p.m. Monday through Friday, and Saturday from 9 to 4. Currently, we do not do work on Saturday. Our intent is to do work on Friday from 9 to 4 only, but we're not going to do the work until volume. We need to do the work on Saturday, rather. There's no work being done at 7 o'clock. We just open the shop up so if people want to drop off their cars or get estimates on the way to work, it's convenient for them. We put our locations on busy streets like this because we don't do a whole lot of insurance work, maybe 5%, 10%, because if you see a $600 repair, it's under or just at most people's deductible. We depend on someone making that split decision to just stop and get their car repaired and just drop it off in the morning, get an estimate, come the next day. Minimum hazardous waste. We have a company called Safety Clean that removes our hazardous waste. They give us 2 55-gallon drums. In fact, after opening the last one, they're going to reduce the size of those drums that are properly grounded. They get picked up once every 3 months, and right now, there's nothing in them. And I'm sure these guys know your waste is money, so waste is minimal in the auto body business. There's nothing going down the drain. Again, we don't do any oil changes. We don't work with any transmission fluids or air conditioning fluids. We've had to find individuals around the area that would do that work if a customer wants it done. But again, we ask the customer to take it there. We don't bring it there to those establishments. All the equipment is state-of-the-art equipment. Obviously, brand new. EPA requires us to filter to 98.6. We filter to 99.1% and above. Filters are changed regularly. When I've been before some towns before, they've said, well, what's going to make you change those filters regularly? If you don't change the filters, your paint booth won't work. It just won't work properly, and you won't get good work out. Cosmetics has been in operation, as I said, for 15 years down in Tampa. They have never had a complaint from a resident, and they have never had a violation from the EPA or any other organization. So, and that's cosmetics. Thank you.
Thank you.
Thank you, Ron. If it's okay with you, the site plan was prepared by Dynamic Engineering, and Brett Skaffinitz is here. I just wanted to show the board the elevation that's proposed for this location, and I think he just has very little information to give to the board, and then we just have one more person, and then I'll go over the variance.
Okay.
And I assume the special exception requirements too, if the board wants to hear them. I'll make comment on that.
Bless you.
Hello.
May I have your name? You're going to take that mic, right?
Oh, yeah, I'll have to raise it up.
Right. May I have your name, please, and spell your last name?
First name is Brett, B-R-E-T-T. Last name is Skapinetz, S-K-A-P-I-N-E-T-Z.
Okay. And your address?
It is 245 Main Street in Chester, New Jersey.
Okay. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
As Mr. Archer mentioned, we're the site engineer for Cosmetics. We've worked on and prepared the plans for the other facilities that Mr. Duckstein mentioned, to which he gained approvals for in Greenbrook, New Jersey, and Union, New Jersey. There's a third one that has approvals but hasn't been constructed yet in Brick, New Jersey as well. Just would like to touch base and show you elevations that we brought with us for the building, what's going to happen to the building, how it is, its look is unique. Obviously, being within a retail corridor, it wants to be given that look to fit in with other buildings along the roadway. The goal here with this building is to mainly touch the northern and the eastern faces of the building, which are more visible if you go by that building. The rear or the southern portion of the building, which faces towards the residential, is just a bare block wall, very earth tone colors. That would remain. No reason to dress it up and provide bright yellow and the blue, which is the cosmetic colors, to that end. And same with the western side. That face is covered with brush. There's trees, growth there. You can't see it. No reason to make the change on that end, as it really won't be seen. But the front and the eastern side, you see the metal panels that will be added. There'll be new glass front, which will be installed in the front of the building, along with a new entry doorway to the far eastern side. There's multiple doors in there in the building today along the front. On the eastern side, there's a continuation of windows, and then 2 new bay doors that are being put in on that side for the movement of vehicles in and out of the repair area inside the building. One other feature, just to point out, in the very front of the building, there will be a canopy over the first 4 parking spaces in the front from the eastern side of the building over. And that's a canopy area, again, in line with what Mr. Duckstein noted. This is about the customer, giving them the experience right at the get-go. When they pull their car up, they're looking to have it inspected. That's the area to go. They'll pull up. They'll be under a canopy, protecting them from bad weather, to where a person can come out, take a look at the vehicle, and begin the inspection process. And in general, that's the improvements that are going to be done to the exterior of the building. Okay, thank you.
Thank you.
Thank you. I wanted to comment before Joe Steiger gives some brief testimony also. Thank you. I just wanted to comment that we're very aware of the planning department's missive to the board. Matter of fact, I spoke with Mr. Flynn about it today. Ron and I had met with him about 2-3 weeks ago, probably about 3 weeks ago, to discuss the project. We brought in the literature that's before you. We sat with David, described, maybe not in as much detail, but perhaps, the workings of a cosmetics. And what Mr. Flynn's response was, okay, look, there's always issues with respect to auto body, so tell the board. He said, he had said at one point that, look, we're probably going to recommend a denial just because of the issue of noise. So we actually commissioned a noise study, which I'm going to request that the board allow us to present, because sometimes there's noise coming from these facilities. But the significance of what I'm saying is that when I spoke to Mr. Flynn again today, and his response to me today was, tell the board all about cosmetics. Tell them how it's different. Tell them that it's not the same. All right? But I also want to point out that in referring to the planning department's July 12th recommendation to the board, I just want to make a couple of corrections, if I could, because we believe that
I'm sorry to interrupt you.
Sure.
But we need to take about a 3-minute recess just to change tapes. Okay? Thank you. Okay.